We're with Ryan Tegnalia. Ryan is a criminal attorney in San Diego, California. He's agreed to answer online questions. These were questions posted related to DUI. So Ryan, let me go into the first question. First question was, I'm not happy with my court-appointed attorney. I was able to come up with the money for a private one. Can I just change lawyers midway through the process?
The short answer is yes, you can. The Supreme Court has decided that not just your right to an attorney, but the right to an attorney of your choice is a constitutional right, and so you are allowed to change attorneys anytime that you like. Sometimes it can negatively impact your case, very rarely, but consult with the attorney first, and they'll make sure that everything goes smoothly. But no, the courts and the prosecutors don't hold it against you if you decide you want to go with a different lawyer than the one that you have.
Okay, next question is, am I obligated to do a field sobriety test, a breathalyzer, or what about a blood test?
Okay, so this question is actually rather complicated. The short answer is you are not required to do field sobriety tests, okay? But most people, over the course of a DUI investigation, they confuse the field sobriety tests with the chemical tests, okay? And so the field sobriety tests are the ones that people are familiar with: the horizontal gaze nystagmus, the walk and turn, lifting your leg, counting backwards, things like that. Those are all field sobriety tests. Those you are absolutely allowed to refuse, and it's recommended that you do. Those tests are simply meant to give the police officers evidence. You could perform all of them perfectly well, you're still going to end up in the back of the squad car going downtown, okay? So don't ever do those. Where it gets confusing is there are two breath machines. There is the PAS device, the preliminary alcohol screening device, and then there is the actual chemical breath test, usually an Intoxilizer 9000. So here's the thing, the preliminary alcohol screening device, which is usually handheld, you do not have to take that, okay? That is a field sobriety test, like the horizontal gaze nystagmus and the walk and turn and all that. That one you're allowed to refuse. However, at some point during the course of his investigation, when the officer believes they have enough evidence that you've been driving under the influence of alcohol or drugs, they will admonish you that you have to submit to a chemical test. And there are two. There is the breath test and there is the blood test. If you get to that point and the officer gives you that admonishment, you do have to pick one of the two, okay? And so, but which one you want is totally up to you. Different lawyers have different preferences. Some attorneys think it's better to do the breath test because of the science in the machine, that they feel they can fiddle with that. Some think it's better to do the blood test because it keeps the officer in the dark as to what your blood alcohol level actually comes back as. They just think it's better for the officer not to know that for purposes of writing their report. But yes, once you get to that admonishment, and they said the officer should state it specifically. Once he says you have to take one of the two tests, you do have to take one of those two.
Okay. Next question was from Martha. Martha says, I blew over the legal limit and was accompanied by two minors in the car. How is this going to affect my charges?
Yeah, well, unfortunately, it'll affect your charges in two ways. One, it is common for prosecutors to charge child endangerment counts, even if no harm actually came to the children, just for placing them in the danger of being in a car with someone who's under the influence of alcohol or drugs. So it is likely that you are going to end up with additional charges on your complaint, the document that lists all of your charges. And further, even if those charges aren't added, or even if the DA agrees to dismiss them, it's likely that the DA, the judge, or both are going to want to increase your punishment a little bit if you're guilty. Increase your punishment a little bit based solely on the fact that you did it with your children in the car. And so that is a more complicated case, and you do have a little bit more riding on it than just a usual, run-of-the-mill checkpoint DUI. So you definitely want to consult with an attorney on that.
Okay, next question we had is from Louise. She says, I have a DUI charge. I currently have a DUI charge. I had another one over 15 years ago. Will it impact my current charge and sentencing?
Okay, the answer actually, the way you phrased it is no and yes. Your first question is Is it going to affect the charges? No, it's not. 15 years is outside of the priorability period. So in California, DUIs are priorable for 10 years, meaning if you get 2 within a 10-year period, the punishment on the second one is going to be higher than the punishment on the first one, all other things being equal. So 15 years is outside of that. However, it's still going to show up on your criminal record. The prosecutor is going to be aware of it. They're going to make the judge aware of it. And even though it doesn't count as a prior, it is going to be made known. And you're probably looking at some additional form of punishment or some, something, even if it's not what it would be if it were a second offense within 10 years.
Excellent. Well, if you have any other questions on DUI for Ryan, just post them in the comments section below, and he'll get back to you with answers.
Oh, thank you very much. And as always, you can reach out to me directly at 619-577-0868. Thanks a lot.
Thanks, Ryan.